Just what's that? It's not working.
All right. Morning, everybody. I'm Dr. David Bagley, and I'm the presiding officer this morning. It is 9:30 a.m., November 9th, 2017, and we are going on record in docket 17-5801 in regards to Hopper Disposal Facility. This final hearing is being held at the Fremont County Library, 451 North 2nd Street, Lander, Wyoming. Present from the council is Chair Megan Lawley, Council Member Tim Flipner, and myself. This conference is being transcribed by a court reporter. For those who can count, which is all of us, except perhaps me, we only have 3 members, so we're to vote on and make a decision today. We will still hold the hearing and gather the evidence, and then we will hold the hearing open. When they are available, we'll read the transcripts, listen to the transcripts, and then we will come back and we will receive your closing arguments in written form. So they won't be oral closing arguments today. We'll receive those in written form, and I'll talk more about that later. And then we will finish the hearing at a later date. I want to let you all know that, but we will go forward. We're all here. We want to hear the evidence, and this is the right time and place. The objectors today are Fremont County Commissioners, represented by Jody Darrow, Fremont County Attorney. Welcome. Fremont County Solid Waste Disposal District, represented by Rick Sollers. With Wyoming Waste Systems, and Scott McFarland. Amy Hansen notified the council yesterday that she is withdrawing as a party and is relying on Mr. McFarland to provide the council with the same testimony, same evidence that she would provide if she could be here. The respondent is the DEQ, represented by James LaRock, and Mike Dimmick on behalf of Hopper Metal Disposal Facility. The order for this proceeding will be as follows, so I'll just describe how we'll go through this. Each party will get 5 minutes for opening statements, and we will be, there's a lot of parties, so we will be, I will be checking my watch. And the openings and closings will be given in order of introduction. Then once the opening statements are given, we'll have the DEQ proceed. This gives the council of the process that's been followed regarding the review of the permit application. Once DEQ has presented their evidence, the objectors will have their opportunity to present their evidence, and we'll go in order of introduction. Once the objectors have had their opportunity to present the evidence, and Mr. Dimmick will present any evidence he has. And then finally, DEQ will present any further evidence that they believe is relevant to any issues that have been raised by objectors. A contested case, and so all witnesses will be sworn in, and they will also be subject to cross-examination and redirect. There will not be any recross. Any questions? And I have one more statement. After the opening statements, at that point, I will ask for the introduction of exhibits. So we will deal with that, but let us go ahead and get started with our opening statements. So we'll start with Ms. Darrow.
Thank you, Mr. Hearing Officer. Do you prefer that we stand or maybe sit?
Yes, that you sit, because all the microphones have been very carefully set up.
That's what I figured. But I better ask. Thank you. So as the council knows, DEQ rules and regulations prescribe what's necessary for an applicant to receive a permit for a solid waste facility. DEQ is responsible for reviewing each application to make sure it meets technical requirements for the application itself and the site requirements. However, the review form used by the DEQ is inadequate for making a determination of whether the site will meet these regulatory requirements. If a reviewer only uses DEQ solid waste permit application review form, this only provides the department with about half the information necessary to make a decision. It covers technicalities with the applications, such as whether the day tap is attached, and whether there's adequate financial assurance, and whether a proper bonding mechanism has been employed. Well, that only gives you a piece of the puzzle. In order for a low hazard, low volume facility to be approved, the site itself also has to meet standards prescribed by the rules and listed in Chapter 6 of the regulations. Both the application itself and the review form used don't include that information. It was determined that this particular application didn't require a site inspection. Well, without written assurances of plans specifying how the regs are to be met, and without a site visit to determine if it's possible even to meet these regulations, the DEQ is unable to make an informed decision regarding regulatory compliance. Therefore, any decision made could be deemed arbitrary and capricious or otherwise not in accordance with the law or regulations. Now, the department might argue it's impossible to determine whether site standards have been met until the site is constructed. But however, as you know, you can't begin construction until the receipt of a permit by Chapter 1, Section 1C of the rules. Other government entities, however, regulate prior to construction by using assurances contained in their applications, which include plans for construction. For instance, Fremont County requires roads, water, and septic systems will be constructed before the approval of a subdivision permit. There is an initial application which lays out the plans. Inspections are performed at the site before the permit is granted. Approval of an application that's incomplete or inadequate. So that outlines some of the technical deficiencies in the process with Hopper Meadows' application. However, there was nothing in the application itself which covered location standards, design and construction, operation, monitoring, or closure standards, 6 of the rules. However, the county also has some concerns as to whether Hopper Metals itself is capable of constructing and operating a solid waste facility in conformance with the rules. The evidence offered today will show that the company's president has not demonstrated an ability in the past to follow the rules. Being a member of the Solid Waste District Board and being warned after investigation and inspection regarding his other facilities. Therefore, we ask you today to consider not only the deficiencies in the process and in the application submitted, but also in this entire review process and Mr. Dimick's prior disregard for the rules. Thank you.
Thank you, Ms. Darrow. Mr. Solers.
Thank you, Chairman. May it please the council and parties. The Fremont County Solid Waste District is objecting to this application in that it believes that the issuance of it was arbitrary and capricious and not in accordance with the law. One of the factors that the director may deny it on is if there's a history of violations. And we're going to show you through the evidence today that Mr. Dimick, whether individually as president of Hopper Metals or as president of Hopper Disposal, has repeatedly violated the laws. There's going to be testimony about an EPA violation that occurred on the reservation when he was working with the Wind River tribes, or actually the Northern Arapaho tribe, where he was specifically told that he could not burn municipal solid waste. 6 months later, he's doing it again at his facility at Shoshone. He is called on it. The very next day, he files an application for a permit, and one of the exhibits is going to show the type of permit he wanted. And that is, I want the simplest permit as soon as possible, thinking that having a permit would then comply with the rules and he could do what he wanted. But from the time he submitted his application, 10 days later, he was caught continuing to burn waste. As a result of that, there was a NOV issued by the Department of Environmental Quality. He's also violated the Fremont County Solid Waste District rules while sitting as a board member. And that is that he was delivering unsecured loads to a C&D facility, and those loads also had MSW, municipal solid waste, intermixed in it. We just found out today that there's another notice of violation that's been issued, and that is for his starting construction on his current facility. So under the authority, the director certainly could have, and there's ample evidence to reject this type of application as not being in the public interest. Additionally, we don't believe as the district that the financial assurance submitted is sufficient. One, it's not sufficient because of his past behavior. Secondly, because it relies upon, in a large part, free recycling that he believes would be available to him under our current rules with the district, when in fact, we don't believe he would be entitled to free disposal of recyclables. Additionally, the statute is very adamant. It uses the word must have a 15% contingency. This one does not. And yet it's been approved by the DEQ and actually posted, and there's been a bond issued. But that statutory criteria is a must, and it isn't there. It's not there on the figures that Mr. Dimick put forth on what he believed it would. It's not even 15% of that total. And then if you add on the additional recycling costs, it's woefully inadequate. At the conclusion, and after hearing the evidence, the district would request that the court issue a decision that this permit should be denied. Thank you.
Thank you, Mr. Zollars. Mr. Levin.
Well, Mr. Zollars and Judy have brought forth most of what I had. I was going to bring up again, so there's no use in going over that again, but I've been doing this for 45 years. I've been in this industry, and some of the things, I was here from Seattle, where we have some very huge, and the regulations are incredible. I come out here and it seems like they're just not there. So my concern here is that, again, are we moving forward as, I'm a resident here now. This is my home. I'm concerned that we're not moving forward in the right direction as a county, as a city, or as a state. We need to start putting some more rules and regulations into some of these permits that are coming out. We need to have some, enforcement. There has been enforcement in the past here that I don't think has been addressed, that I'd like to see addressed. Running the companies out here for Waste Connections, Wyoming Waste, I like to see a level playing field, and I don't see that. It's very hard to compete with someone that can get away with certain violations, I believe, and start permits. I've looked into transferring out of this county, and all I see is it's cost too much money. I mean, there's no, I don't know how Mr. Demick's doing it, but I do not see any financial gain here. I can't do it, and I'm sure that my budget is probably quite a bit bigger than his. So I've made a determination to work with Andy in Fremont County to keep jobs here, to keep the flow coming in here. I think it's something that if we get to the point that flow control needs to be, if people keep hauling out of this area, flow control needs to be something the DEQ or the district needs to look into. Safety is something that my company and myself consider the #1 factor in our business. And I'm concerned that just, knowing, being around the area, that the traffic, the odor, just some of the things that go on around here need to be addressed. I don't think that Mr. Demick's equipment is up to par. I don't know where the equipment's coming from. I think there should be some more regulations on that. I'm concerned about, I have some, people that live in the facilities or live in the complexes around that facility or where he's proposed facility. I think that's going to be added traffic and a hazard. But basically in general, I just don't understand how anybody can put another permit out there for a transfer facility when there are violations that have been going on. We run a clean ship. We get We go through all the right processes. So I believe Mr. Demick needs to too, and I don't think that he has at this point. So Wyoming Waste is definitely against this permit at this point. Thanks, guys. Yes.
Thank you, Mr. Levin. Mr. McFarland?
Thank you, Mr. Chairman. I represent the adjacent landowners to the proposed facility location. Also, Mrs. Hanson, who wasn't able to be here this morning because she couldn't find childcare, has asked me to represent her. She was actually one of the original petitioners that I spoke with, but chose to submit her own letter. So I speak on behalf of her and her husband, who own 2 mobile home parks very close to the proposed facility, as well as the other petitioners living around the area. I'm going to leave the technicalities of the application itself to Rick and Jody, who are more qualified to address that. Our concern as adjacent landowners is strictly the safety and well-being of those people who live nearby, based solely on Mr. Dimick's past performance with his operation in Shoshone, as can be seen from photographic and written evidence that's a matter of record. So I don't want to be redundant either. I know that much of what we have to say will be discussed in more detail by Solid Waste and the Fremont County Commissioners, but it appears from the way Mr. Dimick has responded or not responded to the notice of violations concerning his Shoshone facility, and now the violation that we just received for him beginning construction without a permit, that his intent in operating the newly proposed facility would be no different than his practice of operating the facility in Shoshone, which is that he's basically ignored the law in failing to respond to the notice of violation that he received from the DEQ. And it could be said, although this may seem like an exaggeration, if this were a criminal proceeding instead of a civil proceeding, Mr. Dimick would be met by arrest for having an outstanding warrant. But in this situation, it appears, because it's a civil matter, that instead of being punished in some way, that he's almost being rewarded if this permit is approved because of his continued flagrant violation of notices that he's received and continues to operate. Thank you.
Thank you, Mr. McFarland. Mr. LaRock?
Good morning, James LaRock for the Solid Hazardous Waste Division. We're here today to hear from the public. We received an application for a low hazard, low volume solid waste treatment storage facility. We put it through our process. We think it complies with the rules, but the process allows for public input, and public input improves our process. As you know, when we get significant comments, as we felt we received here, that triggers your decision on this permit. So we're here to explain our process, answer any questions you have for us, and as I said, hear from the public. I've also brought Charlie Plymale, who's investigated Mr. Dimick before and has written both of the NOVs in question here to answer any questions council has, answer any questions public has. So, like I said, we're here to hear from the public. Thank you.
Thank you. Mr. Dimick?
Hopper Metals came to life in 2010. Is when that company started. Hopper Metals is a scrapyard that focuses on scrap metal recycling. In 2013, Hopper Disposal was created. Hopper Disposal was to be in charge of dealing with the garbage and the different things that we did. I came to Wyoming in 2010. I started working here in 2009. If we were to talk about Hopper Metals today, there's been a lot of negative comment, a lot of negative commentary about what the company stands for, misconceptions. But some of the things I think are important to recognize. The company's been in business for 8 years. It's interesting that of that time period, there's one documented offense of which we will talk largely about today. When we think about the 10,000 plus tons of scrap metal that we've recycled in this state, that's a lot of work, a lot of effort. It's a lot of miles that are driven to remove that material to the mills, which Wyoming doesn't have. That's why we ship out of state. So things can be created like rebar and angle iron and I-beams and hubcaps, whatever it might be. But in that time period, there's no violations. We don't have any violations on the road. We don't have any accidents. We don't have any workman's comp claims. Nothing. Not one. So it's interesting to think of a company that has done so much and been here so long, employed people in this community, and there's not anything other than what we have on the NOV, which, again, is not quite as accurate as been written. When we think about Hopper Disposal, it's not a very large company. We do the best that we can. We're in a very competitive area. Hopper Disposal has 0 claims against it, has 0 workman's comp claims, has 0 violations on interstate. There's nothing. All that it's done is hauled thousands of tons of garbage within Fremont County. Our goal with this transfer station is to recycle. It's a hot topic that's been throughout Fremont County, but what we want to do is what's not currently being done. Fremont County is in a tough spot. It's expensive to get material out of this area. Freight is expensive. It's a long way to get to destinations. The county doesn't generate a lot of garbage to justify a lot of expensive equipment to better process it. But what we've found over our time in the industry is we have means to further our efforts to recycle. We have means to further transport waste to places that ultimately makes less money for the customer, that ultimately creates waste that does not have to get pushed into the hole. People ask, how do we do what we do? Well, apparently we do what we do because we keep doing what we do. We don't have debt against the companies. We don't have outstanding partners that say, this is how you have to do things. I have my little brain that says, this makes sense, let's go ahead and try that. When it comes to transfer station in Riverton, we see a need, and the need is to better be able to recycle. So our goal is, what can we do to push that effort forward? Recycling exists to an extent, but we'd like to further enhance that. That's our goal, is what can we do to make it just that much better for our environment. The accusations of what we've done thus far at the Hopper Disposal and Recycle Center, one thing to be noted is we've been working on this process for over a year. As we've seen in the different exhibits, there's been fantastic communication with myself and DEQ saying, what is it that we need to do? How can we stay in compliance? How can we make this work? And to look as things have progressed, I find it interesting that we choose to pick on things like, look at him being a flagrant violator. But on the flip side, we've done everything that we can to say, let's be in compliance. There's a lot on the line right now. I've learned a lot in my time in the recycle industry. And so the goal is, how do we be compliant? We want a facility where grandma can bring her pop cans and feel comfortable enough to recycle it. We want people to be able to drive through and say, this is amazing. Look at what was here. There's nothing but junk, nothing but a piece of ground in Fremont County that is dying. We're in a community that businesses are packing up and leaving, but we're taking a chance to bring something to this community, to bring more jobs, to bring more opportunity to the customer. I'm grateful that we've had the opportunity to get here today and to better explain what our position is. I think it's important to remember that while it's easy to pick on what's happened on one day, we shouldn't forget about what we do every day. And what we do every day is haul a lot of waste. We process a lot of waste, and we do the jobs that not very many people want to do. We're out there in our boots. We're out there in the mud. We clean, and we make this environment a better location to look at. And having the facility furthers our effort to keep so much of the garbage out of the hole because we know how to do it. And we've proven that we're willing to step up to the plate because we paid what we're calling a bond. We've paid that to the DEQ. They've deposited that check. We didn't pay part of it. We didn't seek financial assistance. We paid that cleanup because I believe that everybody should have that God-given right to fail. And if I fail, I've paid my ransom, and they can say, you failed, Mr. Dimick, time to pack up and go home. And I can say, you're right. And they have my money in their bank account to clean up the mess that we may or may not have created. But I know what we're doing is the right thing to do. And I know that today we will see that it's the right thing to do.
Thank you, Mr. Dimick. Thank you all for your opening statements and for being so timely. Appreciate it. So what I'd like to do at this point, we have a number of exhibits. They've not been introduced yet. And what the council has found that's helpful is to try to introduce them, them all or as many as possible now, and then they'll actually come up on our iPads, and we'll be able to then look at them while they're being presented. And we know sometimes that may not be the case. But what I'd like to ask then is, and we'll go through, it looks like we have not that many exhibits have been submitted, but I'll go through and I'll ask what exhibit you'd like to submit, and we'll see if there's any objections to it, and if we can, we'll bring them all on, and if there's some objections, we will deal with those at that time. So we'll start, Ms. Darrow, your exhibits, I see, was it just one exhibit?
Yes, Mr. Hearing Officer. And actually, I'd like to yield its introduction to Mr. Sollers. We spoke with Mr. Ruby ahead of time and agreed it might be better just to label it as WES 19 and let him introduce it, just for convenience sake,
Okay.
if we may.
Yep, you can do that. So, Mr. Sollers, your exhibits?
We have exhibits, counting that one, 1 through 19. Additionally,
So let's do with those 19 here first, because they've been all submitted. Is there any objections from the parties to accepting the exhibits WES 1 through 19? Okay, so seeing no objections, we will accept all those, and they're accepted. Now, you have a new exhibit?
well, it's a new exhibit. We just received it today. It's an additional notice of violation that was issued against Mr. Dimick on November 6th. Mr. LaRock just received it as he was heading up here and promptly provided us all a copy. So we would also like to add, and I passed out copies to the other parties as well. We would like to add WES 20.
Are there any objections to adding this new exhibit?
That's a question on that. I've not received it up until this point, and I think there's some misunderstanding of this NOU as well. But up until I sat in this chair, I've not received this, nor had any opportunity to explain anything about that. So I don't know if it should be submitted or not.
Yeah, and that's why we're asking about this, since it is new. So what I'd like to do is let's hold that exhibit until the time when you're doing your, presenting your evidence, and then we can have arguments further on that. I don't want to rule on that objection yet, but we'll wait until you present it. So the council won't see that until we get there. So let's hold that one. Any other exhibits?
No, those are good.
And DEQ,
Exhibits 1 through 4.
any objections to receiving those exhibits? All right, those have all been received. Are there any other, I don't see any other exhibits submitted. Were there any other exhibits to be brought forward? All right, so we will, all the exhibits that have been previously submitted, West 1 through 18 and 19 was Fremont 01. That becomes WES 19, and DEQ 1 through 4 are all admitted. And we will further consider WES 20 during the evident presentation of that. Thank you all. Okay, so we are ready to now begin. And Mr. Rock, we'll start with you. Please call your first witness.
My first and only witness, Mr. Patrick Troxel.
Do you swear in? Yeah.
I didn't know if it would be you or me.
No, please, if you would.
Yes. Mr. Troxel, would you raise your right hand, please? Do you solemnly state that the evidence you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Hi, Patrick. Can you state your full name for the record, please?
Patrick Joseph Troxel.
Mr. Troxel, where do you work?
I work for DEQ.
How long have you worked for DEQ?
The DEQ since September 28th, 1990.
Is this pace okay? And what's your role at DEQ?
Currently, I'm the supervisor for district solid waste.
How long have you been the supervisor?
I've been supervising this area since about 2000.
Oh. Can you describe your role as a supervisor?
Day-to-day roles, I have an employee workstation and I manage our district workload for the different counties that we cover. I also have my own specific facilities that I review. Some permit applications to ongoing permits, groundwater reports, investigations.
Do you oversee permit applications that come into your district?
I
Do you review them personally?
Some I review myself. I have others depending on county there, and I have an employee who's involved in that process as well.
Do you have any estimate of how many permits you've reviewed?
No, a lot.
A lot? Okay.
Probably since I've been here, hundreds.
So we're here today to talk about a low hazard, low volume permit application. Are you familiar with low hazard, low volume permit applications?
I am.
Can you describe what's required for a low hazard, low volume permit application?
Yes, the rules require that they submit a completed permit application form, a location map, and adequate financial assurance.
And that's it?
Those are the three requirements by rule for a low volume low hazard application.
Can you, and you may not know, but can you guess why low hazard, low volume applications are so bare bones?
I believe originally they were identified as low hazard, low volume due to the fact that they are low volume compared to most facilities. There are requirements for how they operate, such as being containers that reduces the impacts from them. And they're very small in nature.
Does that mean that we just let people do whatever they want with these facilities? Okay. Is there an investigation of facilities generally when we receive an application or after the permit is issued?
Generally after the permit is issued.
Okay. So just to put a bow on that, we don't ask for a ton of information up front because these are supposed to be low hazard facilities.
Correct.
Okay. I'm going to hand you what's been marked as DEQ Exhibit 1. This has already been admitted into evidence, but can you tell the council what this is?
It's a copy of the permit application form, the location map, and the information that was utilized to determine the financial assurance estimate.
Okay.
copy of sanitation rates from the city of Riverton, Riverton Bale Station, Sandra landfill.
So this is everything that was submitted as part of the permit application form under Chapter 6.
Yes, it is.
Okay. When did Mr. Dimick first come to you to talk about applying for this permit?
I don't know the exact date, but I believe Mr. Dimick and I started our conversations back probably in May of 2016.
But he didn't submit this application in 2016, did he?
He did not.
When did he eventually submit this permit application?
Well, this one is date stamp September 11th of 17.
But this isn't the first application he submitted?
I do not believe this is the first.
When he initially submitted an application, were there issues with the application?
There were some things that were incomplete. And I have, there's a lot of communication between Mr. Dimick and I to address those issues and get those insufficiencies rectified.
Was there an issue with the area identified for the facility?
There was initially, it was identified, and the piece of property that was identified was too large to qualify for low hazard, low volume.
But you worked out those issues through communication with Mr. Dimick?
Yes, I did.
Okay. Let's see. Let's talk about financial assurance a little bit. So financial assurance, that's spelled out in this application, right?
Yes, it is.
Okay. Can you turn to those pages real quick? So what is a financial assurance estimate for a low hazard facility supposed to cover?
We don't have a standard form, if you would, for estimation. Each one is based on the specifics of a facility, depending on what they're proposing to do. So typically what we do is we look at the application, what they're proposing to do, and then look at what the requirements would be to, generally financial assurance, we say we need to have coverage in order to, if you would, clean up a facility at what we would call the worst case scenario. So at its fullest point, if it has certain amounts of materials that it's going to store, we would maximize all those and have to have enough to cover handling those and getting those off-site to a proper facility.
Can you describe what the worst case scenario for a low hazard, low volume facility would be?
Well, the worst case is if they are handling all of the waste materials that are listed under the definition of a low hazard, low volume. Would be pretty much exactly what we have here, which is, as an example, there's 100 cubic yards of construction demolition waste. There's 100 cubic yards of municipal solid waste. There's a number of batteries, a number of tires. They can have a certain size pile of clean wood and or green waste. They can have recyclables, things like that. And so what we would do is if they're proposing to do all of those, we would say you have to be able to handle the maximum of all of those. And that's what we had done here in this case.
So Mr. Dimick submitted an estimate of what it would cost to clean up absolutely everything a low hazard facility would be permitted to take.
Correct.
And did you review this financial assurance estimate?
I did.
Who else reviewed this estimate?
I reviewed it, and then I also submitted it to my boss, the program manager. He also reviewed it to make sure that we had kind of covered everything we thought was necessary.
And did anyone in the Cheyenne office review the financial assurance estimate?
I don't, prior to the bond being, or it being submitted to the bonding specialist for taking care of it, no, it was just the program manager.
Okay. And then did Mr. Dimick submit financial assurance for this facility?
Yes, he did.
In what form did he submit it?
He submitted a cash check.
So DEQ has that cash check in case, worst case scenario, he goes out of business with a full facility?
Correct.
Okay. So there was some discussion of location standards in the opening statements. Do permit application forms contain all the information that DEQ needs to ensure compliance with location standards?
They do not.
Is that because the permit application, sorry, I was going to be a really leading question. Why is it that permit application forms don't require that information?
Well, I'm not, I guess I can't say I'm not sure why the permit application form is a 2-page form. And it's used for all of our facilities. So this permit application form couldn't possibly cover everything for all of the facilities that this form is utilized for.
So it's a bare bones application form.
It is.
If we receive complaints about a facility that's not complying with location standards, are those complaints investigated?
They would be.
Okay. And you may not be aware of this, but if you are you aware if we've issued NOVs based on non-compliance with location standards in the past?
At any facility?
At any facility.
I'm personally not aware of anywhere we've issued.
That's fine.
Location standards.
And my last series of questions for you, there's been some discussion also of Mr. Dimick's history of non-compliance. Were you aware of Mr. Dimick's history of non-compliance?
I was aware that there was an NOV, and I was aware there was discussions going on, but that's outside of the purview of my responsibility, so I was not involved in that process.
So you don't know the details, just the general sketch. Okay.
Correct.
When you're reviewing a permit application, do you consider non-compliance when you're considering whether it's technically adequate or not?
I do not.
Do you know who at DEQ has to weigh those decisions before the permit is issued?
For this permit, there's specifically in the rules under the permit denial or revocation section, it's, I think the director is identified as responsible for making that decision.
Has this permit been issued yet?
It has not.
Okay.
We've issued a proposed or draft permit for public comment. That's it.
Okay. So to the extent that Mr. Dimick's prior NOV is relevant, it wasn't relevant to you?
Correct.
Okay. Just review. Patrick, I think that's all my questions.
Thank you, Mr. Rock. Cross-examination, Ms. Darrow.
Thank you. Just one moment, please, if I may.
Mr. Chairman, we talked to Mr. Ruby ahead of time. Can the district and the county simply switch order of cross-examination and calling witnesses?
Yeah, we can do that.
So I'll do mine, then she will.
Thank you, Mr.
Mr. Sullins.
Thank you, Mr. Chairman. Mr. Troxel, and I guess because I know you as Patrick, is it okay if I call you Patrick?
Sure.
Okay. You indicated that in May of 2016, best of your recollection, that's when you were first approached about a permit, correct?
Correct.
And then were you aware that there had been an EPA investigation of Mr. Dimick on the Wind River Indian Reservation in April of 2016?
I was not aware of that.
Okay. And then really you didn't hear back to him, and I believe it's a WES Exhibit 19, which should be in that folder. And there should be a number, so I hope it's clearing back.
Maybe if you look at maybe FRE 01, that's how the Is it now? Okay.
Again, what number am I looking for?
19. Should be the very last document in there. It's a one-page email.
Okay.
Okay, so then, the next contact, I believe you testified, was somewhere in November you heard from him, and that was this email?
This email is dated November 4th of 16.
Okay, and were you aware that on November 3rd, the day before, Mr. Plymell had conducted an investigation of Mr. Demick's facility in Shoshone and found that he was burning municipal solid waste?
I was not aware of that.
Okay, and what that document says is what he's seeking is he's seeking the simplest form of a permit as soon as possible. Am I correct?
It says, I want to be sure that I apply for the right permit, comma, the most simple permit possible.
Okay, so he wants the simplest as soon as possible. And this comes the day after Mr. Plymell had told him he can't burn waste like he was. Correct?
I assume, as I stated, I didn't know anything
Okay.
about the previous day's actions.
Were you aware that there was a subsequent investigation on November 14th, 2016 by Mr. Plymell?
I was not.
Okay. Were you aware that there was based upon those two investigations, that there was a notice of violation issued against Mr. Demick and Hopper Metal?
As I stated, I knew that there was an NOV and that there was work going on, but as to the dates, details, or any details of that, I was not aware of any of that.
Okay, well, I'll represent to you that NOV was issued on January 20th, 2017. So it is filed prior to approval of this application, correct? Based on my representation.
I would assume so, yes.
Okay. You ever do a site visit as far as reviewing an application?
Any application?
Very poor question, I apologize. Do you ever do a site visit to low volume, low hazard permit applications prior to acting on them?
We typically do not.
Okay. Is there a reason for that?
Well, one would be, it's a very infrequent permit. There are very few of them. And two, due to the nature of those permits and the permitting process identified by the rules, that it really isn't necessary or to complete the permitting process.
Are you aware that this proposed facility, from the nearest point of the facility, is located 347 feet from a public recreation hockey area?
I know where the facility is located, but I do not know the exact numbers that you're.
Okay, and knowing that, would you be surprised if I told you it's 700 feet from softball and baseball fields?
Again, I know the location of the facility, but the exact distances I don't know.
A couple more here. Do you know that it's located within, and maybe not the exact distance, but very close proximity, 50 feet to the Stacy House?
I'm not aware of that.
Okay, and 460 feet to the Gordon House.
I'm not aware of that.
Okay, so the proposed permit that's out there doesn't tell Mr. Demick what he has to do, does it? To be in compliance with the rules.
I believe it does. The proposed permit has permit conditions which
Okay.
specifically identify those sections of the rules that he would be required to meet in order to operate this facility in compliance with the solid waste rules and regulations.
Okay, so what that proposed permit says is that one of the conditions is that he comply with all the site requirements of Chapter 6. Correct?
I'm not sure what site requirements means.
Well, chapter 6 on low volume, low hazard facilities have certain site requirements that you have to meet.
If you mean location standards?
Yeah, there you go.
Yes, it's specific, it does specifically reference the requirements and rules for the location standards.
Okay, but it doesn't tell him what those are. Correct? Your permit doesn't specify that these things need to be done on your facility. As a condition, it just says you got to read the rules and comply with them.
Correct. It does not identify all of it identifies the requirement within the rules. And we provide a copy of that with the document. It does not have each requirement specifically listed as a permit condition.
Okay. Now, Mr. Demick has already shown an inability to read and follow the rules. First off, you testified that he originally had a 20-acre site in his application when the rules specify that 10 acres is the maximum, correct?
Can I object to that question? The first part was Mr. Dimick has an ability to read and follow the rules. That's not really a question. Nor does Patrick have the knowledge to testify to that question as he testified earlier.
And that's kind of our decision to make.
Okay.
Yeah, I agree. So, sustain, go ahead and way to ask.
The rules prohibit you from operating a facility without a permit, correct?
Correct.
And he's been found to at least issued a notice of violation for doing that. Correct?
To my understanding, as I was not involved in that process.
Okay.
Do you have an objection?
I do have an objection. For clarity on my behalf, we're here today to discuss hopper disposal, correct? Hopper disposal is a separate company, but we keep coming back to Hopper Metals. I'm striving to seek clarity. Hopper Metals is its own company. Everything is its own separate from Hopper disposal. But I just want to make sure that we're here to discuss Hopper disposal, or if this is a hearing in regards to Hopper Metals and the NOV issued to Hopper Metals.
So, I'll comment and then I'll ask for your thoughts on that. We are here to examine the proposed permit that would be issued to Hopper Disposal. We are here to also hear evidence that may be related to that proposed permit. And now I'll let Mr. Solers comment on the objection before I make a ruling on it.
Well, and while that may be true, that they are two separate corporate entities, according to the Secretary of State's records, both entities were formed on August 21st, 2013. Mike Demick is the president and controlling officer of both corporations. And so what he's asking you to do is say, if one of the companies I run, Hopper Metals, chooses to ignore the rules and not follow them, that you should issue me a permit and believe that this other corporation that I also own rules. So I think his actions as president of Hopper Metals has direct bearing on how he's going to operate this facility under merely a different corporate name. He's still the president of both companies.
So I was actually waiting for someone to have this objection. And so I'm glad it was made. The council wants to hear everything that may be relevant. And we will not be ruling on anything related to Hopper Metals. But we tend to want to hear if an objector feels that some information is relevant. We will err on the side of letting that come forward as long as it's clearly not at all relevant. And it may be relevant that things that have happened to Hopper Metals may be relevant to our decision on Hopper disposal. And so while we will make no judgments at all on Hopper Metals, that's not why we're here. I will allow this questioning to continue as long as I can see that it may be relevant to the proposed permit on Hopper disposal. So, but thank you for bringing that forward, and now we've got that clarified. Please continue, Mr. Sullivan.
Thank you. Patrick, I want to go to the financial assurance. And first off, it's WES 3 and 4. Okay, thank you. It's my understanding that the financial assurance costs are to be determined by a third-party entity. Is that correct?
Yes, that's one of the options.
Okay. Another option is bids. Another option is public information.
Correct.
Okay. And so WES 4 is a financial assurance that Mr. Dimick provided to you. And I believe he did these estimates.
These were provided to me by him, yes.
Okay.
Who put them together, I cannot comment on.
And then when he did the final one, he merely put Dave's asphalt letterhead above it, correct?
I would say the same information appears to be on Dave's asphalt letterhead, yes.
And Dave's asphalt is not a disinterested party, is he?
Could you explain that to me?
Well, Dave's asphalt, if you look at the right-hand side, it says the president's Dave Long. If you look at your application, who's the lessor and owner of this land?
Dave Long is.
Okay, so he has an interest in facilitating this facility so they can lease it out, correct?
I don't know the arrangements that Mr. Dimick has with Mr. Long, so.
Well, you know he has a lease, right?
I don't know that he has a lease. I know that he is using a piece of property that is owned by Mr. Long because Mr. Long signed the permit application as the land owner. Other than being the land owner and giving his approval, I don't know anything else about that arrangement.
And then in these estimates, at various times, during the cleanup of certain items, it says no charge because it's a recycled item at the district. Correct?
Correct.
Okay. Did you verify that the district would take a commercial operator's recycling waste?
The only thing I had done was looked at information that was on the district's webpage.
Okay.
And there was no indications that there was, on the webpage that I saw, there's no indications that there was any discrepancy from what was on this document to the webpage.
Okay. So if there's testimony today that the district does not take other commercial entities recycling material at no charge, and in fact would make them dispose of it themselves, then this financial assurance is inaccurate. Would you agree with that statement?
I would agree.
In fact, it's underfunded, I guess, would be. The bond amount is less than it should be.
I would agree that the information included here would be incorrect.
Okay. You're also, I believe you testified, aware of Chapter 7 and the requirements of what's required for a financial assurance.
Yes.
Okay? And you're also aware that in the financial estimate, it says that there must be a 15% contingency.
Correct.
Okay? Now, I'm not real sure on the last page, and you can look at either one because they're the same. It says mobilization, demobilization variables, variable cost expenditures. Did you consider that to be the contingency rather than the mobilization, demobilization?
I did not.
What did you consider it to be?
I considered it to be exactly what it is, a representation of additional funds for variability and things that need to be done.
Okay, did you ask him if that was for mobilization, demob, or if it was a contingency?
No, I assume by reading it, it's for exactly what it says it's for.
Okay. So you don't have to do the math. I'm going to represent to you that I have added these up, and everything above that $1,000 line, the total is $10,350, which would make sense. That's his total minus the 1,000. Okay. For simplistic forms, let's say it's 1,000. What is 15% of 1,000? It's 10,000. What's 15% of 10,000?
Not the 1,000.
It's 1,500. It's actually $1,552.50 is 15% of the 10,350. This financial assurance does not meet the requirement that you must have a 15%, does it?
It does not.
And that's not even counting if we throw in recycling costs or him having to dispose of those on their own. Correct? That makes sense?
Yeah, again, what I looked at and the information I had, I will agree that there was an oversight on my part and it did not include the 15%.
Okay. I don't believe I have anything further at this point. Thank you. Thank you, Patrick.
Thank you, Mr. Schallers. Ms. Darrow?
Thank you, Mr. Hearing Officer. Good morning, Mr. Troxel. Mr. Troxel, I believe you still have in front of you Mr. Soller's exhibits, correct? All the WES exhibits in that file.
Correct.
And within that application, which is WES 6, there are the maps which Mr. Dimick submitted with his application. I believe they're on pages 5 and 6 of that application. I'll give you a chance to find them. I don't think we have our pages numbered.
You said WES 6?
Yes, and if you can't find them, I can give you a copy as well.
WES 06 does not have any maps.
I'm sorry,
included.
WS02. Maybe I have the wrong exhibit number. Thank you, Rick.
I have
Thank
WES
you.
02.
And looking at those maps, what is their source, please?
The source of the map?
Yes,
Google Earth.
thank you. But not the USGS maps required by Chapter 6 of the regulations?
Correct.
Okay, and this proposed facility is located outside of the city limits, isn't it?
The city limits are not on this map, but I believe it is.
Okay, thank you. And therefore, the regulations require a USGS map, don't they?
They do.
And so this map does not technically meet the requirements of the application?
Correct.
Thank you. On page 3 of the permit application review form, which is DEQ 1, it's the application on page 20, DEQ on page 20, which is also WES 1. Have you found that? Okay.
Yep.
On page 3 of that permit application review form, you stated that the facility is not subject to inspection before the permit can be issued. And Mr. Sellers touched on this a bit, but I was wondering, can you tell us what regulation determines whether or not an inspection is required?
I cannot. I do not believe we actually have a regulation that states that a facility inspection is required.
Thank you. And to touch on the bond again, what kind of bond was posted?
It was cash check.
And turning your attention again to page 20, the permit application under section 8.2.
Excuse me one second. What?
Sure, I'm sorry, that's the page we were just on, your application review form.
Which exhibit is this?
DEQ 1, or also.
WES 6.
Good Lord, I got all my exhibits wrong. I'm sorry, WES 6. Thank you, both of you. Under the, I'll look until we find it.
I've got it now.
Thank you. Under the section headed mechanism, it's 8.2 in the middle of that page. Would you please read out loud the second bullet point?
Mechanisms must be reviewed and approved by SHWD bonding analyst and senior assistant attorney general.
And to your knowledge, were those reviews performed?
Yes.
Okay, and by both entities?
To my knowledge, yes.
Okay. And I didn't see anything in the written evidence that indicated whether or not they were approved. Were they approved?
They were approved.
Okay. Now I'd like to direct your, do you have a copy of the regulations with you?
I do not.
Okay, if I may, hand to the witness, Mr. Hearing Officer, Chapter 6 of the regulations.
Is that a exhibit at all?
No, but I would ask the council to take judicial notice of the regulations as published.
Yeah, we will do that.
Thank
Do you want to
you.
give me mine?
Oh, yes, thank you.
Can I approach it, Mr. Chair, and hand you mine?
Yes.
His is a cleaner copy than mine, Mr. Chairman, so.
Nor my tabs.
All right. I'm going to direct your attention to this Chapter 6, Section 3, subsection B, which I believe is page 17. The pages aren't numbered, so I don't know why this chapter doesn't have numbers on them, but. After this, it should be smooth sailing and going in order, so I hope.
Lowercase b.
Yes. So it's about a third of the way, or a quarter of the way down the page.
I have it.
Okay, thank you. Thank you for your patience, Mr. Hearing Officer. Direct your attention to this, and according to subsection 4 under subsection B, facilities shall not be located in an area where there is potential, as determined by the administrator, for the facility to present a dust or odor problem or public nuisance, unless the facility operating plan specifically addressed that. Did the application address any such potential nuisances or problems?
It does not.
And you mentioned that you didn't perform a site inspection before approving the draft permit, correct?
Correct.
Okay, let's move to subsection 5, small v of section 3B there. This contains requirements for outdoor facilities. So on that second map in Hopper Metals application, I noticed that it depicted something called process/storage corners. To you, does that indicate that there could be outdoor facilities for processing?
I'd have to look at the map you're referring to. Is it the previous map that we looked at?
Yes.
Depending on how you read it, I believe that the map and my discussions are, those are corner markers for the property itself.
But we don't have enough information from the application to know for sure, correct, whether or not there's going to be any outdoor facilities?
Correct.
I'm going to direct your attention to WES 02, which is one of the maps. Yeah, that's fine. So I don't know if you can answer this if you haven't done a site inspection, but to your knowledge, what are those process/storage corners indicating?
I would make an assumption and did assume that they are, that the actual facility operations would happen within those boundaries.
But again, you can't determine from this map or the application, can you?
Correct.
Moving on to design and construction standards, and this is set forth in chapter 6, which you've got there, section 4. Let's take a look at subsection B, which is 3 pages past the page we're just on. If I'm correct.
Okay.
And then actually, I'm going to move you one more page forward. Subsection 1, which is a small I. It requires a sign. So to your knowledge, does the facility contain a sign that complies with the rules?
I don't know if the facility has a sign.
And the application doesn't include information about plans for signage, does it?
It does not.
The application also fails to address the signage for equipment as required by subsection 2, doesn't it?
The permit that was submitted does not include information other than what was required for them to submit by rule.
The application doesn't address the requirement in subsection 4 that waste management units shall be designed and constructed to contain the waste within a unit and prevent the migration of contaminants either, does it?
It does not specifically address that standard.
In fact, the application strangely makes no mention at all of how solid waste will be managed, does it?
Correct.
And then one last bit of the regulations here. Section 5 of Chapter 6 addresses operating standards. So I'm going to move ahead to page 26. I believe we were on page 21, so if you'll page ahead 5 pages there.
You said section 6?
Yes, and we'll be looking at subsection B3 on that page.
Okay.
Okay, thank you. This states that all waste shall be confined to solid waste management units and equipments as specified in the permit. However, the draft permit doesn't specify how waste will be contained, does it?
The waste containment is addressed within the rules under the definition of a low hazard, low volume permit.
And what does that include?
Containers. It talks about the specific waste that must be in order to qualify, in order to be defined as a low hazard, low volume, there are specific wastes that must be contained within containers or a building.
Okay. And again, the application doesn't address whether or not there will be indoor or outdoor facilities, correct?
Correct.
Let's see here. And this application also doesn't address fire protection pursuant to subsection 4, does it?
It does not.
Or litter collection, a program as per subsection 5?
It does not.
And it also doesn't address dust or odor minimalization. That's a tongue twister, does
It
it?
does not.
And the application doesn't address monitoring or closing standards either, does it?
It does not.
Right, that's all the questions I have at this time. Thank you.
Thank you, Ms. Darrow. Mr. Levin.
I just have one question. You believe the permitting for the low volume transfer station is adequate?
I don't have an opinion on that. My job is to review permits and ensure that they comply with the rules. And in this case, I did that, and the rule, he submitted all the information required by rule, and my determination was that he met the requirements of a permit submittal.
So basically, that's a different answer for a different question, but I mean, you're saying that you're not sure the system's adequate, but he fulfilled everything in the system, and that was adequate.
Correct, sir.
Thanks, Steve.
Mr. McFarland.
I have nothing until closing argument, or closing comment.
All right, thank you. Mr. Demick. Questions?
I'd like to point out that I think Patrick does a fantastic job at what he does.
Mr. Chairman, I'd like to object. If he wants to question Patrick, that's one thing. He's making a statement and testifying, which comes later.
Yeah, we, at this point, if you have some questions for the witness, that's what we need to hear. Statements, we have another time to do that.
Patrick, in your opinion, do you feel you're very good at what you do when it comes to your job?
I do.
You feel that you're very good, you have a very good understanding of the rules that you're asked to govern and to?
Feel that I do.
Do you feel like you've been honest in your dealings as we proceeded with this permit?
I do.
Thank you.
Thank you, Mr. Demick. Any questions from council members? Chairperson Lawley.
Mr. Flitner, I've got a couple. One, just a clarification, and I may have missed the point on this, but if I understood it right, the application is for 20 acres?
10.
Or 10?
The application is for 10 acres.
So where did the 20 acre figure get thrown out there?
When the permit originally came in, Mr. Demick, when he filled out the paperwork, he actually put in the size of the piece of property that is owned by the landowner. And then after discussions with him, and I informed him that you can't have a 20-acre facility to qualify for low hazard. So he pared down what part of the property that he was going to utilize for his facility to comply with the rule of 10 acres.
So this 10 acres basically sits inside of the 20, maybe not centered up, but it's part of that 20.
Yes, sir.
So basically, we're looking at, depending on how we place it, and I'm looking at the map, so I think I have an understanding, but there's certain parts out there going to have a 10-acre buffer zone.
Correct.
I mean, it may be nothing in one side, but it might be pretty wide in another.
Correct.
Okay, and as far as the bond, when you lay that all out, there's so much of each product that he can store there at any one time. Is that correct?
That is correct.
And that bond should cover that.
Correct.
So, but that doesn't necessarily mean that's part of his business plan. That's just what he's allowed to do, right?
Correct.
Okay.
If I may clarify, when we do financial assurance, the low hazard, low volume rules have a very specific list of things that you can do. If you propose to do all of them, you can. People have submitted applications at multiple facilities where they do not include everything. And so if they're not going to do everything, when we do financial assurance, we look at what they're proposing to do. Permits are issued to do what they propose in the application, and the application document lists those at the bottom. So if he were to, in that example, list 2 things, we would look at what he's proposing to do and base our financial assurance decision on what he's proposing to do, not what is the universe of things that could be done under the rule under that type of permit, if that makes sense.
Okay, one last thing. There was a question about storing any of these products outside.
Yes.
Does this permit allow for that? And is it one of the things that he's allowed to do in this permit?
He would be. There are, I believe, 2 items in this permit that would be allowed to be stored outdoors outside of a container. The rule specifically states there are certain products that must be in a container. And then there are 2, I'll call it 2. We put green, what we call green product or tree trimmings, et cetera, and clean wood. Those are considered, they can be outdoor piles, as well as a certain number of tires. Those can be stored in outdoor piles. They could be in a container, they could be in a building, but they're allowed. There are other products that by definition and by the rules for low hazard volume must be in a container.
And this is my last thing, I'm done, but we're going to have to get to this sooner or later anyway, because it sounds like there was an error on 15%.
Correct.
So that's going to have to be fixed, right?
Correct.
I mean, so if everything else would just, for argument's sake, sail all the way through and none of the council has a problem with any of the rest of it, you don't have any problem going back there and amending that to make that right.
No, not at all.
That's all.
All right, thank you. I have a couple of questions. Could you, and I'm sure it's written somewhere, but I can't find it readily. Could you define for council what low hazard and low volume means? What other things that it could be? What is low hazard, low volume?
Would you like me to read the definition by rule to you or my understanding?
You have the rule. I mean, if it's not too long.
Just chapter 1.
Yes.
If I may.
It's a little lengthy, but
I'd like to hear it just because it's not really in front of me.
sure. Low hazard or low volume treatment, processing, storage, and transfer facility means a solid waste management facility which accepts only solid waste as described in this subsection. This provision does not apply to facilities whose owner simultaneously owns or operates more than one such solid waste management facility within 1 mile of each other.
Mr. Hearing Officer, this definition, just for your benefit, goes on for 3 more pages and has a lot of subsections. I don't know if you're interested in the whole thing.
Well, so the first part's good. I guess what I want to hear then is how much, or the key things, like your,
Okay.
because I kind of see some things in this application, but the application is very brief. And so,
I can do that easily.
yeah, let's do that, please.
So one I already spoke about is clean wood, waste storage. It has to be an area no greater than 10,000 square feet or contains 100,000 cubic feet of clean wood waste. And then it has to be 100 feet from off-site structures. And then there's a requirement to manage stormwater, and the piles can't create a public or private nuisance. The facility itself has to receive less than 50 cubic yards or less of solid waste per day, and it can occupy no more than 10 acres, which includes a 20-foot buffer zone within a fenced facility boundary. Then there is
So just,
Okay.
I gotta have a fence, and then I can't have anything up the fence. I gotta have 20 feet from the fence before I have anything.
correct.
Okay.
And then there's recycling materials, cardboard, plastics, aluminums, etc. And those can be done. Make sure precision sorting. And then 500 gallons of used oil.
Per
I'm sorry,
day,
5,000 gallons storage on site.
storage on site.
So 5,000 gallons of used oil, 5,000 gallons of used antifreeze, 1,000 scrap tires, which are stored in compliance with Chapter 8, which is a special waste chapter, which has to do with how big a pile can be, separation from other things. Mostly it's for fire protection. Green waste and clean wood waste storage piles, which we talked about before, those sizes. Compost piles. Household hazardous waste collected no more than quarterly and has to be taken off-site within 30 days. 50 cubic yards of electronic waste other than CRTs. 50 cubic yards of CRTs. Now, as an example, the 50 cubic yards of electronic waste has to be in a container. Of CRTs in a container, 500 batteries, and they have to be stored upright, not leaking. 100 cubic yards of construction and demolition waste in a container. 150 yards of mixed solid waste, which can be, generally we refer to that as MSW. It could be a bunch of different of the solid wastes. That has to be in a container. And that's it.
So as I look at the application, I see basically those numbers. So the applicant went through, looked at it, wrote those numbers down, wanted to have the ability to, basically, as you said, some applicants will specifically not want to examine one thing, but I think I saw all of them listed.
Correct.
Okay, so, and where was that defined, just for my?
That's in Chapter 1 of the Solid Waste Rules and Regulations.
Okay.
Specifically, it's Chapter 1, Section 1, lowercase b.
And so, now when it comes to, I saw this review form, one of the exhibits, I don't remember which one, where solid waste permit application review form. And as you go through and these things are listed, has to have general information, it has to have a map, financial insurance. Where in your rules is that information coming from that tells you this is what I need to be looking at?
The information on the checklist?
Yeah.
So we have a very large checklist that we utilize for our full landfills.
Okay.
A lot of the information, there's a lot of location standards that are similar for different projects.
Okay.
That review form, when we use a review form, sometimes we will take an existing review form for another facility because it has applicable information. It will take and get rid of the non-applicable parts and reuse it so that we don't have 7,000 different forms. But the information specifically for that comes out of Chapter 1, which is the permit application requirements that are spelled out specifically for a low volume, low hazard permit.
Okay.
And it tells you in that section, it specifically lists those three things that I've included on the review form. Those are identified in the rule as required submittals for a low hazard, low volume permit application.
Okay. So these things being submitted, and then you check those and say everything is okay. And you did mention, as we see here, there should be a USGS topographic map, and that was not what was received.
Yes, sir. Would you mind if I address that?
Yes, please.
In this day and age, I can tell you, I haven't had a USGS map come in with a facility probably for a very long time. It's much more common for people to use Google Earth. There's so many other things that are, quite frankly, better maps for them to show us where something is than a USGS map. And I understand that the rule says a USGS map, but it's very common for us to accept alternative maps, provided they give us the kind of detail that we need, which is being able to figure out where they are. You know, what town are they near, have an address on them, things like that.
Okay. I guess one thing I didn't see on that map, which when I saw that you could have up to 5,000 gallons of used oil, I don't see any topography on this. You know, and I guess when I think of 5,000 gallons of used oil in a container, I worry about it leaking and where it will go, and I wouldn't be able to see that if I didn't have the topography.
True.
So I would hope that that kind of thing is being thought about. But that brings up another question. So for this case, you're not doing any kind of risk analysis on what if 5,000 gallons of used oil starts leaking. You're not doing that risk analysis in advance on this.
Correct. And that would be the significant difference between this type of low hazard, low volume permit and a full-blown Chapter 6 permit, because that's the next step. My understanding is that the way the rule is developed and the way these facilities are processed is because they are low volume, they represent a low hazard, and there's a stipulation that so much of it has to be in containers. There's also management requirements for used oil that they have to meet. And the way the permitting process works, we issue, as is indicated in the draft permit, the permit has conditions that they have to meet. And part of that, when you look through those references, because they're all so long, that within all of those documents, it addresses things similar to that, which is used oil has to have secondary containment. There's certain things you have to do. So there's other processes that they have to follow that aren't, Mr. Sollers asked me about that. They're not specifically spelled out in our permit, but they are referenced by a condition within our permit. And we provide those as an attachment to the permit when it goes out.
So that's presumably been put together with an understanding, if you use secondary containment and everything else, that the risk is very low, sort of based on experience, put the rule together in that manner.
Correct.
So you don't do a separate assessment for the low volume, low hazard facility on that, as long as folks are following the rule and you send that information along with and then the applicant must read through that and follow all those things.
Correct. And then the mechanism for doing that is through the inspection and enforcement program of inspecting facilities and then making sure that they are following and doing what they're supposed to do.
Location. And the reason I'm asking these questions is I don't think I've been involved with a case that has low volume, low hazard, but I have been on the council when we looked at a large, was a very big issue in that particular case. So I want to know what's the location standards relevant to a facility like this. How close can we be to things?
Well, in this case, most of them, the standards, if you look at them, the most common you'll see is 1,000 feet. And if you're more than 1,000, you can be located more than 1,000 feet. If you're located within 1,000 feet, what changes for this type of facility is you have to be screened from view. So that means if you're in a building or if you're, for instance, a recreational facility or a school or a house, you can be less than 1,000 feet near that facility, but all that means is that you then have to screen it from view. So fencing, berming, we've had people plant trees. There's a myriad of ways to comply with being, with the visibility issue. It doesn't restrict you from being that close. In theory, you could be right next to a school piece of property where there's a school, but you would have to fence it and you'd have to make it non-visible. It doesn't mean you can't do it. It just has a requirement for visibility.
And that's in the chapter rules.
Correct. That is specifically listed as a location standard.
All right. So I'm looking at the law, 3511-502. Part A, Part C, and it lists a mile of the boundaries, a mile public school, this sort of thing. And so I'm hearing that doesn't appear to apply to this thing.
I believe in the statute there is a section specifically for low hazard, low volumes.
Okay. So it's a different part of the statute.
It's in that same 502, and I think it's at maybe the top of the second or third page. It's on the right-hand side. I remember looking at it.
Well, you'd be the expert on it. Okay. So the chapter 6 location numbers that we've heard numbers, those don't apply specifically to the low volume, low hazard. Like so many feet from this or so many feet from that, as long as you screen it.
Well, there's a requirement that if you're within a certain distance, and if you would like me to address those quickly, I certainly can read those to you. Chapter. Does anybody have chapter 6?
I took it back. If I may here, Mr. Chairman.
And Mr. Troxel, that should be the 17th page back.
I think it's tab.
Yeah. So the location standards specifically state that and I will paraphrase, they cannot be located in conflict with local zoning or ordinances or land use plans that have been adopted by the county.
How do you check that?
Well, and so we don't check that. That is one of these location standards, the way the process is set up and the way the rule is set up, that the application process, they come in with those 3 requirements. We ensure that they meet those and that our permits are issued with conditions that are given to them and that so that they have, before they can build their facility and operate it, we refer them to these and say, you've got to meet all these with your facility. And then once the facility is built, we would confirm that they're being operated in accordance with the requirements through the inspection and compliance program.
So in theory, a proposed permit could be issued by the state, and yet the operator would not be able to operate because it didn't meet the county's rules. That's kind of what I'm hearing.
I suppose that could happen. Yes.
Okay.
In this case, I can tell you, when I started this process, I supplied all of this information to Mr. Dimick. And I typically do with people if they come to us ahead of time and say, I'm going to apply for a permit, what do I have to do? We sit down with people all the time and say, here's the rules, here's what you have to do. Here's the permitting process. We go through that with them. Here's how it's going to work. But this one specifically, low hazard, low volume, is the only process that we have by rule that says you only have to submit these 3 things.
Okay.
If you go to the full-blown Chapter 6 permit, which is the next one from this one, you actually have to, in your application, which comes in very thick,
Right.
you then have to supply us with information because the process requires that you pre-demonstrate that you have met all of this.
Okay.
So the low hazard, low volume is the only one. I kind of refer to it as permit by rule,
Okay.
which is there's a standard. You've done the minimum application requirement, and now we tell you after that, you can operate, but here's the standards you have to meet once you start operating.
All right. Yeah. This has been very helpful because,
Okay.
like I said, I haven't had the experience with this type of permit. And I was surprised to not see things that I've seen in other larger permits.
This permit is used pretty infrequently. We're seeing it more now because of other programs we have going on with the small communities and closing their landfills and needing. But I would say up until real recently, very rarely used for facilities.
Yeah, I have one more question. So I have one last question.
Yes.
When was this particular rule related to low volume, low hazard facilities, when was it last updated, reviewed?
Well, the chapter 6 of the rules the last one was written in 1998.
Okay.
But the definition of a low hazard, low volume facilities, which has the volumes, which also have the container requirement and all of that, those have most recently been updated January of this year.
Okay.
Chapter 1, which is where the definition of it is.
Thank you.
You're welcome.
Chairman Bowles.
I guess I just have one question. How many of these facilities exist in Fremont County? Even a ballpark.
I'm guessing 1, 2, 3, 4. I think there are 5 low hazard, low volume facilities
Okay.
in Fremont County.
Okay, thank you.
Well, there are currently 4. This would be the 5th if it were permitted.
Okay, thank you.
You're welcome.
All right, Mr. LaRock, any redirect?
Well, Dr. Bagley, you covered a lot of what I wanted to cover in redirect, but just to reiterate, Patrick, is the application for a low hazard, low volume facility require the operator to submit design and construction standards?
It does not require that.
Does the application require them to submit operating standards or an operating plan?
It does not require them to submit that.
And that's by rule.
Correct.
Thank you. I have no further questions.
All right, thank you. Do you have any other witnesses?
No, although we have Charlie here in case anyone else wants to call him.
Okay. So I think what I'd like to do is, you may sit down.
Thank you.
Thank you. And before we move on then, since Mr. Rock has no other witnesses, let us take a 10-minute recess for whatever activities people need. Oh, so we promulgated those rules.
It's chilly.
Thanks.
You guys are like frozen.
Well, I figure we can. You're working like crazy. You expect to see like everything, right? And we're like,
It might
it's possible that we as the council may want to do safety.
Thanks, Patrick.
Next round.
Everybody here? All right, Mr. Solers, please call your first witness.
Thank you, Mr. Chair. The district would call Charles Plymell.
Please swear him in.
Would you raise your right hand, please? Do you solemnly state that the evidence you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Plymell, so we have it on the record, please state your full name.
Charles Allen Plymell,
And are you employed?
employed by Wyoming DEQ, work in the solid hazardous waste department and inspection compliance enforcement.
Okay, and what are your duties in the inspection and compliance?
Inspect and enforce the DEQ rules and regulations.
Just as to permitted facilities or any activity?
Any facilities that fall under the solid hazardous waste rules in Wyoming, permitted or not.
Okay. Are you aware of Mike Dimick, the president of Hopper Disposal?
Yes, I am.
And just briefly, how are you involved or aware of him?
I've inspected his facilities.
Okay. In March of 2016, were you involved in an investigation with the EPA on the Wind River Indian Reservation?
I was not involved in the investigation on the reservation
Okay, and why was that?
because the reservation doesn't fall under our jurisdiction.
Okay. Do you know what the allegations were there?
I am aware of those, but I would feel that those ought to be directed to EPA because that was their investigation on the reservation.
Okay, but you're aware of them?
Yes.
Unfortunately, EPA isn't here. Can you tell us what you were aware of?
Okay. EPA came to investigate illegal dumping on the reservation, illegal burial of waste on the reservation. There were complaints that came in to EPA on Mike possibly burying waste on 17 Mile Road and at an old transfer station facility or directly to the north of there. But EPA came in to investigate illegal dumping on all the transfer station locations, waste not being hauled out, and illegal burial of waste and burning of waste on the reservation.
Were there any determinations or findings made by the EPA that you're aware of?
I am not aware.
Okay. Were you invited to go on that reservation tour?
No, I'm not very comfortable with this. We don't have any way to verify or check on this. He's obviously stated twice now that he's not comfortable with this line of questioning. I mean, we're off the reservation here, fellas, and I don't like it. I don't know what the rest of the council thinks, but we've got no way, I mean, to verify anything. And he's not comfortable with it, which makes me not.
I'll move on. That's fine. Mr.
Yeah, I was gonna say, waiting to see if any lawyers would object, because it's technically hearsay. We do occasionally allow that, but I agree with Councilman Flipner. Let's move on.
That's fine, I will. In November of 2016, did you receive a complaint regarding Mike Dimick and Hopper Metals in the Shoshone area?
I did not.
Did you do an investigation on or about that date?
I did.
Okay, and what was the investigation centered around?
I was on my way back from Casper and noticed a lot of smoke and burning coming from his location. So I called Mike, got permission to access his property. He could meet me at that time, went out, saw that waste had been being burned in some large containers. And then I met with Mike Dimick the following day out there.
Okay, and what was discussed between you and Mr. Dimick?
That there had been waste burned in those containers. It was obvious it had been MSW and that was not allowed.
Okay, and you took photographs?
I did.
In that file, there's some photographs under the label WES 8. And are these the photographs that you took?
Yes, they are.
And do they accurately reflect what you observed on Mr. Dimick's property on that date?
Yes, they do.
Okay. And you discussed it with him. You told him he couldn't burn municipal solid waste. Did you do a follow-up inspection?
Around November 13th, 14th.
Okay. And what did your follow-up inspection reveal?
The follow-up inspection revealed the same containers, same waste. It wasn't determined if there was new waste that had been added to these containers or not, but they were still burning.
Okay. And did you complete a notice of investigation form with regards to these activities?
I did.
Is that exhibit WES 9?
That is one of them.
Under the bottom, it says other comments or observations. I'm having a hard time reading that. What does it say?
MSW burned from Shoshone or Lye site, some in Riverton, but limited. Quit hauling reservation waste end of September. The other containers at casino were sold to the casino.
Okay, thank you. Did you do a subsequent follow-up inspection on December 22nd? And I'll point you to WES 11.
That was when air quality went out to look.
Okay. Okay.
So that wasn't an inspection that I conducted, but I was present with air quality.
Did you, to your knowledge, was there a notice of violation issued against Mr. Dimick?
Yes, for the burning on November 2nd.
And was that at your recommendation?
That was one that I drafted and issued.
Okay. So the notice of violation is exhibit, excuse me. Your letter recommending it is exhibit 10.
Correct.
And it doesn't only involve the burning of MSW, it also involves excess tire storage?
Correct.
Okay. And in fact, a notice of violation was filed?
Correct.
Okay, and that is, I think exhibit, the second part of exhibit 12, is that right? Is that correct?
Correct.
Okay, and it was filed on January 10th of 2017, correct? or at least that's the date on it.
Correct.
Now, under the rules, if you know, and I don't know how much you know, once a notice of violation is filed, is the alleged violator entitled to respond to the notice of violation?
They do. In this particular case, when the NOV was sent out, I believe it says in the cover letter. When they're sent out, then we give them a certain amount of time to contact us. And usually if I don't hear from them, I make a phone call or send another letter to make contact with the individual or company that the NOV was sent to get an opportunity to come in and meet with us and resolve the notice of violation. In early February, I reached out to Mike, and he came in, met with myself and Greg Meeker from Air Quality, sat down, discussed the NOV, discussed voluntary settlement. After that meeting, he had 10 days to respond in writing on whether to settle or not settle the notice of violation. And we didn't hear anything from Mike Dimmick within that time frame, so that NOV was referred on to the Attorney General's office.
Okay. So to your knowledge, that case has never been resolved and is still pending?
It is still, it's within the AG's office.
Okay. I believe it was September of this year. Did you also receive a complaint regarding the facility that's at issue here?
I did.
What was that complaint?
I was told that the facility had already started construction. So I went over there and looked, and they had started pouring concrete for the scales.
Can they under the rules, can they start construction without being issued the permit?
No.
Okay. Did you indicate that to speak to Mr. Demick about that?
After I went out and noticed that they'd already started construction, I called Mr. Demick, and he did confirm that they had started pouring the concrete for the scales because of the limited time frame before winter. And I let him know that that wasn't allowed, and so they immediately stopped.
Okay.
I object to that. I'd like to do that. This scale that's in the picture here, does this scale belong to the landowner?
So you'll have an opportunity for cross-examination. For asking the question as a cross-examination, an objection would be that the question asked, you don't feel is appropriate for us to go down that pathway. So you'll have a chance to ask that specific question to the witness when it's your turn.
And has a notice of violation been issued as a result of your inspection and determination there was a violation of the rules?
Yes, correct.
It has not been admitted yet. This new notice of violation is WES 20. I would like to move for the introduction of WES 20, which is a new enforcement action signed November 6th, 2017 against Mr. Demick. I just received it today, so.
Could you tell me to whom it's addressed?
The cover letter is addressed to Mike Demick, Hopper Disposal. It's signed by Luke Esch. And the parties, it's in the matter of the notice of violation issued to Mike Demick and Hopper Disposal.
Are there any objections?
I object.
Your objection is noted. I will allow this to come in as evidence.
Okay, can I approach the witness? Mr. Plymell, is this the notice of violation that was just sent out within the next couple days?
It
The
is,
last few days.
it is.
And it addresses the construction prior to being issued a permit. Okay. I have nothing further. Thank you. Thank you, Mr. Plymell.
Ms. Darrow?
I have no questions for Mr. Plymale. Thank you.
Thank you. Mr. Levin?
Just one question. Was there any, after the newest NLP was sent out or you talked to Mr. Demick, was there any more work after that that you're aware of?
Other than if I would pull off the concrete, there was nothing else done.
Thank you. Mr. Demick?
I'll start with the scale. Was the landowner contacted of activity going on on his property?
As far as,
apparently there was some concrete that was poured on a piece of ground. Was the landowner contacted?
I don't know. I wasn't doing the construction, so.
So is it fair to say that the scale could belong to the landowner?
The scales that were being built were on the site that was proposed and permitted, and that was the exact location the permit was proposed for. So there was activity going on at the location for the proposed permitted site.
So if we were to look at the proposed site and if we realize that the scale is not in the proposed boundaries, is it fair to state that that scale could belong to the landowner and not to Hopper Disposal?
The scales were being constructed in the proposed boundary.
So if I may, if someone can give you the map. I know it's not a USGA, but on the corner where it shows the process storage, the scale does not sit inside of those boundaries.
Objection, is there a question in there somewhere?
Yeah, I think what he's asking, you guys are saying two different things. He's saying the scales is not inside the proposed boundary, and you're saying they are, the construction of that scale. So which is it?
Well, just a minute. So we had an objection to the question, and because there wasn't a question. So could you've handed him the map, rephrase in terms of the question, please.
Is the concrete on the ground that will probably house a scale inside of the proposed process and storage map provided?
There's a map here that says scale house, transfer building, exhibit WSO2. Is that?
So it says scale house.
Mhm.
That's not a scale, correct?
Correct.
And is that inside of the boundaries of?
I don't have the boundaries in front of me.
So I would move that it is not inside the boundary as detailed in this map, nor is a scale.
Just a minute, please. So, there's nothing to move. We're not voting on anything. And you've asked a question. The witness has not really answered the question, at least to my satisfaction, but that there may be another way to answer that question.
If I may.
Yeah,
Here's the problem with admitting evidence that hasn't been confirmed. I mean, what we're looking at is your opinion of what he did wrong. And that's why there's a process with NOVs that we go through. So that in the end, if there's a debate, this council will decide if it's truly an NOV or not. Or you guys get together and figure it out yourselves. But bringing this forward as evidence and saying this is an NOV that is valid, We're not there yet. And so it's hard for me to consider that as evidence of a strike against Mr. Dimick when we haven't validated it yet. It hasn't gone through the process. So, and this is the problem we face now is it or isn't it? Well, we don't know because we haven't gotten there yet. And when we have two completely differing opinions, this is not the place to decide that. So unless somebody has something unrefutable that they can bring before us right now and say, here it is, then this thing is not really any good to us. We shouldn't be hearing it.
Let me respond. I allowed the evidence to be admitted because it's related to Hopper Disposal, and that's who we're examining. We do have a specific process, as Mr. Footner has said, for examining NOVs specifically. And Mr. Dimick may want to avail himself of that process. When you get an NOV, you're able to respond to that, and it could come before us specifically on that issue. And you've asked the question, and I'll give the witness one more chance to answer it, and then we will have to move on. And we're not solving the NOV, but it's certainly, I think it's legitimate for him to ask a question related to it, but we're not going to resolve the NOV, and we will have to move on. So your objection now, specifically, what are you objecting before we continue?
That Mr. Dimick was making argument and not cross-examination.
Okay, thank you. That's I agree. So, but I will like before I would like you to now you are going to clarify something. So please clarify that.
By this map, it shows the southwest boundary, northwest boundary, northeast boundary, southeast boundary. That scale, the scales that are being constructed are within those four corners of boundary. So I have not seen the full proposed permit for this facility. So if those scales are in that proposed boundary for this facility, as what I have seen, yes, they would be in that proposed boundary. But the NOV, by verbal conversations with Mike Dimick, the scales were for this facility, and that's why the NOV was issued.
Okay, so we have an answer. May not be an answer that you want to hear, but that's we have an answer. So let's move on to if you have some additional questions.
Okay. Let's go to what you stated about the burning incident at the yard in Shoshone. You said you were driving down the road. Is that correct? And you noticed smoke or burning? So I use the term smoldering. Was something smoldering or was something on fire?
Something was on fire. There was a large quantity of smoke and flames coming from your scrap metal.
From something. Did you see anybody there burning?
There was nobody on site that I could see. That's when I made a phone call to you to access the property.
So would you say that you did not see Mike Dimick burning garbage?
I didn't see Mike Dimick on the property.
Okay.
But Mike Dimick did admit during the phone conversation that they had burned on the property.
But my question is, you did not see Mike Dimick burning. Okay. I'm not good. I've read a lot of the rules, but I would ask, was there an authorization of consent to enter the property and to take photographs?
Verbal.
Verbal. Was it stated what the purpose or the intent of that was going to be?
Yes, it was.
So how do I disagree?
Well, you can't. You're just asking questions and he's answering them.
Okay.
And council imagines you disagree. And this is also related to a specific NOV. But that NOV, which hasn't come before us, is another opportunity. That you have to sort out separately. But so we're hearing the answers. We're hearing your questions.
Okay. Okay. In regards to when you came back the previous time, you said you looked into the same container. You could see that something was smoldering. Is that correct? Or something on fire?
On the 14th, there was still stuff smoldering.
Something was smoldering. It didn't appear that there was any new waste added to it, correct?
Correct.
Can you verify by your photographs if that was MSW or if that was something else that is legal to burn?
It was by solid photo just maybe. In exhibit WES 08, photo number 2 shows various cans, other, burnt paper, burnt plastics, burnt, basically MSW materials. Again, in photo number 4, so it shows the same materials. And photo number 9 shows same materials. You can obviously tell that there's plastic bags, papers, basically MSW waste.
Charlie, your experience with stuff that's been on fire, is it fair to say that that could have been tree limbs? That it could have been clean lumber? Based on conversations we had previously, it is legal to create fire in Fremont County. Number 1, to burn limbs. Number 2, to create warmth if a worker was utilizing that for heat. Is that correct?
The photo documentation clearly shows that it wasn't tree limbs.
But on the 14th, when you came back and saw something that was smoldering, there was nothing burning, there was smoldering ash.
They were the same container.
In the same containers, but the question is, was the ash the same? Was the ash MSW, or could have the ash been wood?
The ash was MSW. It was the same
So you can't,
material.
but you can't verify that it was not wood. I don't mean to argue, and I don't know how to do this.
I think we're getting your point. Yeah, he's answered your question, but we've heard your question, and we've heard his answer, and we take all these things into consideration. So go ahead and move on.
I don't know how to say it wasn't what was burning wasn't what was documented. I don't like I said, I don't know.
He didn't take a sample and have it analyzed, and so that level of uncertainty remains. So we can go ahead and move on.
Correct. Okay. In regards to so do I discuss the NOV, or is that not the place for this item? As far as if I wanted clarity on what was actually what's written here, if I said I think it's relevant to the case as far as what I'm accused of.
You have an opportunity when we're all done with hearing evidence to prepare, and it will be a written closing argument where you can lay out all of your arguments as to why this is not relevant or that's not relevant. At this point, if you have any more specific questions to ask him while he's at the witness stand, we can do that.
Okay.
Yes, Mr. Flitner.
Do you plan on testifying yourself? I mean, do you plan on taking the witness stand and taking the oath? And
I was prepared to do that. I thought that was probably the best and most honest thing I could do.
Because all the things you want to get across in your own words. I mean, granted, everybody's going to be asking you questions as well that you may not want to answer, but that would be the time to explain yourself the way you can now.
Right, because right now we're formally in this, you got to ask questions.
Okay. Then my last question would be in regards to tire storage. Have you and I had disagreements on what the difference is between tires as a recycled product versus tires as a nuisance?
Yeah.
So is it, in my defense, if I strive to create a recycled product that in essence has violated the storage requirement, but not in the grounds of we're storing illegal tires, we're striving to recycle based on the product that we make?
In the state of Wyoming, tires are not considered recyclable material. They are considered a solid waste.
But it's in our conversation.
So anybody in the state of Wyoming, baling tires needs to have a permit. Anybody storing tires over 1,000 tires needs to have.
And so in our discussions, Hopper Metals, where the tires were at, it was also discussed that we do have a permit to have up to 1,000 scrap tires based on the current permitting of that facility. Is that correct?
There's no permit, but there is a standard where you can have up to 1,000 tires without.
Okay. And I guess for the sake of, when you were there to see the tires, would you say it was a massive nuisance, or was it within the parameters as far as, they're gonna, don't know how to say, you didn't come up to a pile of 5,000 tires, say there's nothing going on here, this is a operational, they're striving to get rid of them.
Tires were coming in, being baled, they were being disposed of at the Shoshone landfill. With the investigation that I did, there were times that tires were excess of 1,000 tires, and there were times that tires were under 1,000 tires. Each time tires were pushing the 1,000 tire limit or over, and it was told that you needed a permit for having more than 1,000.
Okay, thank you. In regards to the meeting that you and I had regarding the NOV when I came down to Lander, do you recall what was the voluntary settlement?
Within 10 days, you needed to notify by writing, email, or letter that you wanted to voluntarily settle. He said verbally that you definitely wanted to voluntarily settle, but it was also stated that you needed to do so in writing within 10.
What were the options for voluntary settlement?
There was a cash settlement that was proposed. There was a proposal of supplemental environmental projects that could be submitted to be determined if they were acceptable by the state for a supplemental project, and there were no supplemental projects proposed.
And can you recall a rough estimate of what the dollar amount was for voluntary settlement?
I don't have it. There were two different amounts. There was one if we voluntarily settled. There's one if it went to the AG's office that they would see.
May I suggest what that number was?
You can ask him if that number, you can ask him if the number is what he rings.
Mr. Fallon, do you recall if the number was around $15,000 for voluntary settlement?
No, it's not.
Mr. Fallon, would you recall if I was given the option that I could go out and clean up tires in Fremont County and still be assessed a fine of approximately $4,500?
That was not. It was either a supplemental project or pay a penalty, and the supplemental project would have to be accepted by the department.
And would you agree that within that 10 days, where there was nothing, let me rephrase the question. To your knowledge, has anything happened since that day other than this letter was submitted to the Attorney General? But as far as communication with yourself, has anything happened since then to say we need to resolve this issue?
Yes, I've contacted you and said that it needed resolved, and then you said you.
But is there anything, my question is there been any formal, other than a phone call, hi, how you doing? Is there anything formal that says we need to resolve this issue?
After it's submitted to the AG's office, then we don't.
So to your knowledge, you've done all that you could do to that point.
And I can, Mr. Flintner, if you guys want those amounts, I can get them to you.
Okay, that's all.
All right, thank you. I'm sorry, Mr. McFarland, I forgot to ask you any questions, but you said you didn't, but do you?
I do not.
All right, thank you. I'll try to remember to ask anyway, just to be correct.
Thank you.
Mr. Rock.
No questions.
No questions. Council members. Chairperson Ollie.
Yeah, I had a question. And I think this was partially answered in questions, but what substances are Mr. Lee, let me try it again. What substances is Mr. Dimick allowed to burn under his permit?
He doesn't have a permit, so he's not allowed.
No, in the, for Hopper Metals at the other facility.
He doesn't have a permit, so he's not allowed to burn.
Okay, thank you.
Okay. So is that the letter that we looked at earlier after that NOV was issued? He
said, what do I need to do to get permitted to burn? The simplest and easiest route to get that done. Is that what we were referring to?
I believe so.
So he did follow up and say, make me legal, right? In whatever quickest and easiest way we can get there. Help me out that way, right? And what follow-up was there after that? I mean, whose court is the ball in at that point? Do you then submit, or tell him where to find the form to fill out and apply, or how does that work?
Anything that has to do with permits, I refer them to the permit.
So he would have then been referred to them, he would have submitted a permit to burn. And to your knowledge, did he do that?
I don't know. The permitting stuff would have gone through air quality. It wouldn't have gone through ours.
But that was the last incident of the burning anyway, right?
Correct.
Okay. That's all I got.
So I just want to understand, we got these NOVs floating around. So the first notice of violation that you mentioned was related to copper metals, correct? And so that's a different facility than the one that we're talking about today for proposed permit.
Correct. That's his facility located in Shoshone.
Okay.
Recycle that.
Now, there's a violation that was just entered into evidence that is still working its way through the system. That was related to the hopper disposal facility that we are examining the proposed permit. Is that correct?
Correct.
Okay, so the two different locations and two different operations.
Correct.
Okay. Thank you. That's all.
Yeah, one quick comment, just so everybody knows where we are with this, because from where we are up here, we're looking for things to help us make a decision. And while the NOVs are part of that, they are going to be far from the biggest part for several reasons. First of all, we don't know if they're NOVs yet. I mean, we know they're issued, and we have no reason to doubt the capable people at the DEQ. However, there's a process for this. So I guess my warning is, don't spend all day on the NOVs, because in the end, what we're faced with up here is to make our decision based on the law. And be a pretty good argument to say the law would throw out these possible NOVs completely. And we have to take that into consideration. We will do our best, as Chairman Bagley has said, to consider these things, and we will. But so far, we spent a whole lot of time on these NOVs. Maybe a little bit more than we should. There's a lot more to this case than this NOV. So if you have other stuff to bring, we need to hear some other stuff too. I think we're all getting a really good handle on these NOVs by now. And we can read between the lines. This ain't our first one. So, I'm just saying, let's try to get on to some other stuff pretty quick, because we can't make our decision solely on whether we think he's guilty of these NOVs or not. That is not going to be the biggest part of what we make this decision on today. So,
thank you, Mr. Flinder. Mr. Lawler, I'm sorry.
I have one more question. Notwithstanding what Tim just said. Where in the process are the two NOVs? So that I can understand whether either of them are final.
The first NOV has been referred to the Attorney General's office.
But has not come before the council yet.
Correct.
Okay.
And then the second NOV has just been issued.
Okay. Thank you.
All right.
Ms. Lally?
Yes.
Just for clarification, NOVs don't come before the council. NOV and orders come before the council. NOVs go to the AGs and then they deal with them elsewhere.
Okay, well, I know several who come before the council.
Those are NOV and orders.
Okay.
There's two different things.
Okay.
So you got to add the word order to it.
Okay. Okay. Thank you.
So, having heard Mr. Flitner's discussion, which I mostly agree with, Mr. Sollers, any redirect for this witness?
Kind of afraid to. Kind of like Councilmember Lawley, my first question is, on the 208 NOVs, it names Mike Dimick personally, correct?
Correct.
As well as the two facilities.
Correct.
And to clarify, there was some difficulty on where the scales were at. And you testified that Mr. Dimick had told you that they were pouring the scale pads where they're located on that map?
They're real close to them.
Okay. I have nothing further.
All right. Thank you. You may step down.
Thank you.
Do you have additional witnesses, Mr.
I
Sellers?
do. I have one additional witness.
How long do you think that will take?
My direct will probably take maybe 10 to 15 minutes at most.
All right, so let's go ahead and do your next witness, and we'll plan to break recess for lunch after that.
Okay. I would call Andy Fry.
Would you raise your right hand, please? Do you solemnly state that the evidence you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
So we have it on the record. Please state your name.
Andrew Dale Fry.
And you're employed?
Yes, sir. I work for the Fremont County Solid Waste Disposal District as the Superintendent of Operations.
About how long have you worked there?
Approximately 6 years.
Okay. Just briefly and generally, what are your duties?
My duties would include a myriad of things, but administrative, regulatory, IT, fleet management, staff management.
Okay. When Mr. Plymell testified, there was a discussion about the number of transfer stations in the county, low volume, low hazard. Does the district operate any of those?
Yes, sir. We operate 6 low hazard, low volume transfer stations in Fremont County.
Okay. And where are those located?
We have one just outside of Pavilion, one along Missouri Valley Blacktop along Bushwhacker, one northwest of Lye Site, one within right at the edge of the town limits of Shoshone, one 7 miles outside of Jeffrey City, and then one what I would call mostly west of Atlantic City, about 2 miles.
Okay. And at those locations previously, there were landfills, is that correct?
In the general area, yes.
Yeah. You used to also operate one at Hudson?
Correct. That was closed, yes, sir.
Okay. And is it accurate to say that these transfer facilities were put in rural areas to serve the residents of those areas in lieu of the landfills being closed down?
Yes, sir.
Okay. Are there any other low hazard, low volume transfer stations currently that you're aware of?
No, sir. Not that I'm aware of.
Okay. Now you're familiar with Mr. Dimick?
Yes, sir.
And how are you familiar with him?
Of course, through regular operations, but Mike Dimick was also on the board of directors that oversees the solid waste district.
Do you know when he was appointed?
He was appointed in December of 2013.
And what's the term they served?
They served 3 years, so his term would have started January 1st of 2014.
Okay. Did he serve his full 3 years?
No, sir.
If you look at WES 16,
Yes, sir. I would hear.
Okay. Is that how he came to no longer serve on the board?
Yes, it is.
And who's it from?
This letter dated April 19, 2016 was from the Fremont County Commissioners.
Okay. And their rationale? Did they state a rationale?
It states that he was removed for a conflict of interest from the district board of directors.
Okay. You also indicated that he was a contractor that dropped waste or whatever at the district sites.
Correct.
Has it ever been, let's look at WES 13.
All right, I have it here.
Okay. Have there been allegations of him violating our district rules in his operation?
Yes, sir. Would you like me to discuss what this letter is?
If you discuss what this WES 13 is.
It's a letter dated December 7th, 2015 from both myself and the chairman of our board, revoking site access at the Shoshone landfill from Mr. Dimick, regarding multiple occasions where him and his company had delivered loads of MSW to a C&D permitted landfill. 2 occasions where his company failed to make payment for waste delivered. And then referenced multiple occasions where his company had failed to comply with secured load policies and the reports from our staff where he tried to use his position as a board member to get around complying with the rules.
And this was in December 7th, 2015, so he was still a board member.
Correct.
About 8 months later, WES 14, did he tell you what he had done to rectify?
Yes, sir, he did in a letter.
Okay. And as a result of his actions, were his privileges restored?
They were restored, yes.
If you would find WES 3, and it should be a financial assurance.
Yes, sir, I have it here.
Okay, in that document, it lists various materials that he claims there would be no charge for disposal, and bases it upon district brochures. Does the district offer a recycling component to its operations?
We do, yes.
And how's it paid for?
Our recycling and waste diversion programs are subsidized through our user fees.
Now, looking at those items, there's electronic waste, CIT, larger volumes of used oil and used antifreeze. Does the district accept those in that volume, those volumes?
We accept volumes that do eventually get to this nature, but for commercial generators, it's been a practice of the district not to accept certain commodities such as used motor oil and used antifreeze.
So, and I can't remember what's oil. Yeah, it's in the application. Here it is. So if you have if somebody collected 5,000 gallons of used oil as part of their commercial enterprise, would the district take that at no?
No, that would not be accepted.
Okay, and they would have to find their own disposal.
Correct.
What does it cost the district to dispose of used oil approximately?
Well, the last time we had used a vendor to get rid of used motor oil, written down here, it was 17 cents a gallon.
Is that fairly recent?
Yes, that was about a year ago.
Okay, how about used antifreeze?
The last time we used a vendor to dispose of used antifreeze, it was $5.60 a gallon.
Okay, how about the CRT?
We pay approximately 39 cents a pound under our current agreement for CRT containing e-waste, and non-CRT containing e-waste, 29 cents a pound.
Okay. And so if this facility was filled to capacity and had to be closed, the district would not take these at no charge?
The used motor oil and used antifreeze would be a practice that we would enforce that. The CRT or the electronic waste at a significant volume would ultimately go in front of our board.
Okay. Does the district recycle scrap metal?
We do.
And do they recycle it themselves or do they bid out contracts?
We bid it out through a competitive bid process.
And did we recently do that?
We did. We awarded a contract at the July 2017 board meeting.
Okay, and whom to?
The contract was awarded to Hopper Metals.
Okay, have there been issues with that?
Yes, there was quite a few issues with getting the contract started. We eventually started work in October, but let me see the date here. I'm sorry. It was the contract that was awarded was found in breach at the October 2017 board meeting.
Okay, and that's because Mr. Demick wouldn't and indicated he couldn't do the work?
Correct. Through conversation, he contacted us and said he'd conduct the cleanup, but couldn't fulfill the obligations for the remainder of the contract.
So his bid was to pay the district how much per ton?
$55 per ton.
And have you had to find an alternate?
We did. In fact, just yesterday, we awarded it to an alternative scrap metal processor.
What are they paying us?
$42 per ton.
This line of questioning, I question its relevance, and it sounds like we're trying to get information on the record for a breach of contract case, not for the permitting process.
Absolutely not, Your Honor. What we are presenting to the board is additional evidence on Mr. Demick's unreliability. Is saying in applications that he's going to do one thing and then not following through, and it's coming through at a cost to other people. For instance, the bond. If the district won't take those recyclables, then his bond is insufficient. The state of Wyoming are ultimately going to have to pay that deficiency. Likewise, he's bid a contract at a certain price, won't fulfill that contract, won't fulfill his obligations, and now it's going to be at a cost to the taxpayers of the district.
In this case, the questions up to asking who get the new bid are fine, but I don't need to know who got the new bid or what they're paying. I consider that irrelevant to this case.
It would only be to show the council the cost to the district for his non-performance, which likewise could be a cost to the state of Wyoming under a non-performance under this permit being applied for.
Well, I understand, but I think that point is been
I'll
made.
move on. Does the district object to the issuance of this permit?
Yes, sir, we do.
And can you tell us why?
The environmental concerns associated with the notice of violations that have been issued to Mike Demick.
Okay, any other things?
I'm sure there are, and I'm coming up with a blank right now. I apologize.
Okay. The district also has a facility in relatively close proximity to this, correct?
Yes, sir, we do. We have a facility probably within 1,000 feet of this location.
Okay, so how is Mr. Demick's facility any different than the district's facility?
Well, the facility that the Solid Waste District runs in close proximity is a full Chapter 6 transfer station, permitted Chapter 6 transfer station, I'm sorry. And we also run a recycling facility there as well.
Are you subject to more stringent regulations and rules than a low hazard, low volume transfer station?
Absolutely, yes.
Okay. I have nothing further.
Thank you, Mr. Saunders.
Ms. Darrow?
I don't think I have any, I don't have any questions. I'm sorry.
Thank you. Mr. Levin?
Andy, our question is you said there were 6 low volume sites presently.
Correct.
Were there not more here recently?
We did have another one that we operated outside of Hudson and closed.
And we had nothing, you weren't in charge of 11 of them at one time?
I believe what you're referencing are some of the transfer stations that are located on the Wind River Indian Reservation, and those are not permitted as low hazard, low volume transfer stations.
What are they permitted as?
They're cited through EPA.
And to your knowledge, has Mr. Dimick ever performed any duties on those sites?
It's been my understanding that he has worked with the Northern Arapaho tribe to provide some commercial hauling.
And as Mr. Plymell testified earlier, that the EPA there is an investigation, to your knowledge, there is an investigation on those sites, correct?
To my knowledge, there was an investigation. I'm not certain if there's anything currently.
Thanks, Amy.
Thank you. Mr. McFarland?
No.
Mr. Dimick?
Yes. I'd like to start with on behalf of character. Andy, when Hopper Mills was awarded the bid in July of this year for the scrap metal contract, there was a follow-up conversation a couple of weeks after that with you and myself on the phone. Do you remember that conversation?
Yes, if you're referring to August 1st.
So shortly after August 1st, the date of August 9th, you and I had another conversation. Do you remember what was discussed in that conversation?
Not specifically.
On August 9th, my dad was killed in a motorcycle accident. I was awarded a contract of which our company would perform. When Andy contacted myself, I was up front.
Your Honor, again, this is testimony, not questioning.
Correct. This is character building of why.
You'll have a chance to bring these things forward, as Mr. Flitner mentioned, when you testify yourself. So please, stick to the questions.
Agreed. Andy, has the scrap metal project as initially approved in that contract been completed?
No, it has not.
How many tons are lacking? I guess it's probably irrelevant to the conversation.
Right.
Would you say overall that what was issued in the contract as far as doing this job, the initial bulk of the cleanup has nearly been completed, if not all completed?
Well, there's 2 components to the contract. Which one was the cleanup? One was the container.
The initial one was.
The cleanup component, I believe, is now complete.
Is completed. So it would be fair to say that although there have been issues, Hopper Metals has fulfilled at least the initial one part of that contract.
Half of the contract.
Okay. But it has been completed.
To my knowledge.
Okay. So, Your Honor, so in lieu of my testimony, when we talk about other things that was inside the district, I'm better off, if it's not directly a question, to just save that for testimony?
Yes. Yes.
Okay. I'll be done.
All right. Thank you. Mr. LaRock.
Just 2 really quick lines of questioning. Andy, have you as a superintendent overseen the permitting process for a low hazard, low volume facility?
No, I have not.
Not a renewal or anything?
Renewals, I would have. Yes, sir.
When you submitted a permit application for a low hazard facility, what do you have to submit?
It's been a little time. I don't recall specifically. I'm sorry.
That's fine. Would it be fair to say that it's an application form, a map, and financial assurance estimate?
Whatever the rules and regulations would require, yes, sir.
Okay. And there's been some discussion about location standards. You said you have a ground, you'd said within 1,000 feet of this proposed facility?
Yes, sir.
And does that facility comply with the location standards?
It's currently permitted, so I would assume it does.
Okay, thank you. No further questions.
Thank you. Any questions from the council?
Mr. Flipner?
Ms. Lawley? Just one question. I noticed you have an engineer ring.
Yes, sir.
What's your degree?
Civil engineering,
Where from?
South Dakota State University.
Okay. Just had to notice, because, you got a ring too. I don't have any relevant questions, I'm sorry. So, redirect, Mr. Sellers.
None.
Thank you. You may step down. And we will recess until 1:30 for lunch.